A tragedy beyond comprehension. That is how the boss of the world football has described the crush at a match in Indonesia that has killed at least 125 people. It's thought to be the deadliest stadium disaster in more than half a century. FIFA President Gianni Infantino said his thoughts were with the families of the victims. It happened in Malang on the island of Java, where fans of a local team ran onto the pitch after they lost against their bitter rivals. Police fired tear gas. As panic spread, thousands surged towards the exits where many suffocated. A warning: you might find some of Shelley Phelps's report distressing.
Chaos erupted as fans stormed the pitch moments after the final whistle on the match which saw Arema lose at home to Persebaya Surabaya. Players had to be ushered away by security. Police say they started firing tear gas in response to the situation.
It was the feeling of disappointment that prompted the supporters to go down to the field to ask the players why they lost the game. That's when the security team moved in for prevention efforts, so they won't get onto the field or interact with the players. During that process, in the prevention effort, tear gas was fired because it had gotten anarchic. They started attacking officers, they damaged cars.
The tear gas caused the crowd to surge towards the exit, where many people were crushed. The tragedy is already one of the world's deadliest sporting disasters, and the number of fatalities is rising. Scores of injured people are being treated in nearby hospitals. In a statement, Indonesia's Football Association expressed its deepest condolences for what happened to football lovers in the country. Indonesia's president has ordered the authorities to thoroughly re-evaluate security at football matches.
Assalamualaikum warahmatullahi wabarakatuh.
I regret this tragedy and I hope this is the last tragedy to occur in Indonesian football. We cannot have any more in the future. Sportsmanship, humanity and brotherhood in the nation should be upheld together.
The Premier Football League has been ordered to suspend all matches until what happened has been investigated. Shelley Phelps, BBC News.
Well, joining me from Bali in Indonesia is Resti Yurolunia, Asia reporter for the South China Morning Post. So many victims. Have they all been identified yet, Resti?
The police said that dozens of bodies are yet to be identified, and indicating that they might be teenagers or children because the age limit to get citizenship ID in Indonesia is 17 years old. So it's also quite telling that a lot of teenagers and children are becoming the victims in this tragedy.
Scores of people in hospital as well, so presumably, unfortunately, the number of dead could well rise.
Yes, because we are receiving conflicting reports from the police and also the local institutions, including the Search and Rescue Agency, because the police so far has said that officially 129 people killed, but we are also receiving reports from the Search and Rescue Agency that at least 174 or 182 victims in this tragedy.
Pitch invasions, football violence, not uncommon in Indonesia, but is it uncommon for police to use tear gas and fire it inside the stadia?
It is rare that the police actually disperse the crowd inside the stadium using tear gas, but somehow it's not shocking for a lot of Indonesians because we often see the police heavy-handed approach to disperse the crowd during riots, during protests, especially in Jakarta and other big cities. They quick to use tear gas, but it is very rare for them to use tear gas inside the stadium. Normally, like when there's riot during football matches, they use tear gas outside of the stadium. So everybody was taken aback by this heavy-handed approach by the police.
Yeah, I was reading, actually, I didn't know this beforehand, that FIFA rules regulate that police in attendance must not carry tear gas or indeed firearms. So this is flouting the FIFA rules themselves. One other issue, though, is that it seems that 3,000 or 4,000 more people were allowed into the stadium beyond its capacity. What is being said about that?
There are criticism about that because normally during the night matches on the Premier League, they don't broadcast it for TV, or like they wouldn't allow like audience, especially during high rivalry matches like Arema versus Persebaya, which are first rivals. So everybody criticized that they actually allowed more people and they actually broadcast it. It's all for TV ratings. So it's also like one question that they will have to answer during investigation.
Good evening from New York. I'm Chris Hayes. Weeks after the FBI executed that now infamous search warrant at Donald Trump's home in Florida, seeking classified documents he removed from the White House, the ex-president filed his first legal response in court. And if you recall, it was basically an attempt to stall the FBI investigation. He asked the court to appoint a special master to sort through his baseless claims of executive privilege over the documents the FBI found at Mar-a-Lago. Now, part of what was striking about that move is that Trump and his lawyers went out of their way to bring the matter before a new judge, not the federal magistrate judge that was already handling the case. No, they filed a motion as a new legal action that was assigned to a different federal judge who, as luck would have it, turned out to be someone that Trump, appointed. That's Judge Aileen Cannon. Trump announced his intent to nominate Cannon in April of 2020. She was confirmed by the Senate in the lame duck session that year. That's after Trump lost the election while he was trying to contest it and ultimately overthrow American democracy. Now, federal judges are randomly assigned to cases, but we know that Trump has tried to get before Judge Cannon previously. In fact, earlier this year, when he sued Hillary Clinton and former FBI officials over the Russia investigation, which was subsequently thrown out, he filed the suit in South Florida, where Mar-a-Lago is. But as the Daily Beast reports, when his attorneys formally filed the paperwork, they selected a tiny courthouse in the sprawling federal court district's furthest northeast corner, a satellite location that's 70 miles from Mar-a-Lago. They ignored the West Palm Beach federal courthouse that's a 12-minute drive away. Now, the scheme failed. Trump's case was assigned to a Clinton-era judge who called him out for basically forum shopping in a footnote. Quote, "I note that plaintiff filed this lawsuit in the Fort Pierce division of this district, where only one federal judge sits, Judge Aileen Cannon, who plaintiff appointed in 2020. Of course, we should be clear, there are plenty of judges throughout the federal judiciary who were appointed by Donald Trump who, when faced with cases that he had an interest, have done the right thing, refused to do his bidding, followed the law. That's largely what happened in the aftermath of the election, when several Trump-appointed judges shot down his bogus challenges. But I gotta say, Judge Aileen Cannon has really distinguished herself as a chilling example of what it looks like when the judiciary is just completely in the tank for a politician. On Labor Day, she issued this order granting Donald Trump's request for a special master, an order that was roundly, nearly unanimously criticized by legal experts, including some of Trump's most staunch defenders.
The opinion, I think, was wrong, and I think the government should appeal it. It's deeply flawed in a number of ways. I don't think the appointment of a special master is going to hold up, but even if it does, I don't see it fundamentally changing the trajectory. In other words, I don't think it changes the ball game so much as maybe we'll have a rain delay for a couple of innings.
So Bill Barr's prediction came true just a few days later. Last week, an appeals court did strike down key parts of Judge Cannon's ruling. The three-judge panel, two of whom were appointed by Donald Trump, unanimously ruled she was wrong to prevent federal prosecutors from using the classified documents in their investigation while the special master reviewed them. They said the ex-president, quote, has not even attempted to show he has a need to know the information contained in the classified documents. And then there's the special master himself, who Trump's lawyers suggested and that Judge Cannon chose. He has not been quite what I think the Trump folks were likely hoping for. Judge Raymond Dearie, a long-serving federal judge with a very, very good reputation, has taken a no-nonsense approach to the case. In a filing last week, he essentially called Trump's bluff, just as he did after the election. The ex-president has been running around making outlandish claims in public, this time alleging the FBI planted evidence during their search at Mar-a-Lago.
The problem that you have is they go into rooms, they won't let anybody near them. They wouldn't even let them in the same building. Did they drop anything into those piles? Or did they do it later? There's no chain of custody here with them.
Just asking questions. Did they plant evidence? Now, evidence being planted has happened, we should be clear, by law enforcement officials all over the place, okay? But if you're going to make that accusation, you need to present evidence. So Judge Dearie ordered Trump and his lawyers to state whether they believe anything on the official inventory list of items the FBI seized is wrong, basically challenging Trump to show him where the planted evidence is in a court filing, which would be subject to sanctions if they were lying. Yesterday, guess what? Judge Aileen Cannon jumped back in to protect Trump and his lawyers from the embarrassing proposition of having to state the plain truth, that no, of course, nothing was planted. Judge Cannon also blocked the swift timetable Judge Dearie had set to resolve the review of the documents, slowing the matter down. With each action she takes, it is harder and harder to conclude anything other than that Judge Cannon is fully biased in favor of the man that got her job, Donald Trump. It's an important reminder that in the end, the judiciary, and more grandly, the law, is ultimately just what a bunch of judges say it is, particularly what 5 justices on the Supreme Court say it is. And this week, we were once again reminded of the fact that those justices are just human beings, like all of us, with a complex set of beliefs and influences. As we've talked about before, one of those Supreme Court justices happens to be married to a person who believes wild, dangerously false things. I speak, of course, of Ginny Thomas, wife of Clarence Thomas, who believes the 2020 election was stolen from Donald Trump. A false belief. She actually worked to further Donald Trump's attempted coup. And yesterday, she testified about her actions before the January 6th committee. She answered the committee's questions for 4 hours and told them she still believes those false claims about the election, which does not make me feel great about Ginny Thomas's general level of processing of the world. Now, I want to be super clear here, okay? People are not responsible for their spouse's opinions. Lord knows I don't want Kate held responsible for like 98% of my own hot takes. But in the case of Ginny Thomas, who her spouse is undeniably relevant. One of the things the committee has wanted to ask her about is her email conversations with, for instance, John Eastman. That is the infamous author of the so-called coup memo, the legal mind who is plotting the coup. Ginny Thomas knows John Eastman, likely had his email address because he's a former clerk for her husband, Clarence Thomas. Committee likely also asked Ginny Thomas about her text messages to Donald Trump's chief of staff, Mark Meadows, in which she shared conspiracy theories and implored him to help Trump overturn the election. Now, any other random conservative activist in Northern Virginia likely would not have the personal phone number of the president's chief of staff. Ginny Thomas did. Because she's conservative royalty. Because, to a certain extent, of who her husband is. And just think about what it would look like if someone like John Eastman or Ginny Thomas were on the judiciary. Remember, the rule of law is not some abstraction. It's not the force of gravity. It is a human institution occupied by humans. So far, by and large, it has held, even as Donald Trump has tested it. There's no guarantee of that. And right now, Judge Aileen Cannon is demonstrating what it looks like when the rule of law doesn't hold. Congressman Jamie Raskin, a Democrat of Maryland, sits on the January 6th committee. He also served as the lead impeachment manager in the second trial of Donald Trump, and he joins me now. Congressman, from an institutional perspective, I wonder how much you think about the human nature of the institutions that ultimately are the guardrails that hold things in place.
Well, the rule of law is an edifice that is populated by real human beings. And so the character of our judges and the character of the people who get involved in every level of government, local, county, state, federal, is of essential importance. That's why elections are so critically important in a democratic society. And, you know, it's a remarkable thing that anybody out there believes that Donald Trump won an election that he lost by more than 7 million votes, in which Joe Biden beat him 306 to 232 in the Electoral College. It is amazing that you have someone who's married to a Supreme Court justice who is, continues to promote the big lie. But of course, that is her absolute First Amendment right to do so. And anybody can go out and, make an idiot out of themselves by claiming that, the Easter Bunny is real, that Santa Claus is real, and Donald Trump is the real president.
Yesterday, Ginny Thomas answered questions before the committee. Chairman Thompson said she reiterated. Look, it's one thing if people thought the day after the election or 3 weeks after the election was stolen. There was no evidence. It was easy to see that was not true then. It was easy to see that was not true on January 6th. But speaking in September of 2022, before the committee, to continue to hold to that belief is a striking thing and a revealing thing, I would say.
Look, people have a right to challenge the result of elections, and the way they do it is they go to court. And Donald Trump and his team did that. And in more than 60 cases, federal and state judges, including 8 judges that were nominated to the bench by Donald Trump himself, rejected every claim of electoral fraud and corruption. So when people are out there saying that, well, I don't know exactly how, I don't know where, but there was fraud, that just flies in the face of everything that we understand about how to make a democratic society work. And again, there have certainly been periods in our history when the courts have been owned lock, stock, and barrel by particular corrupt forces in the country, but nobody can assert that here, and nobody has even tried to assert it about any of these courts or any of these judges. And you read these opinions, and they're just blistering, denouncing the nonsense that is being put forward without any evidence at all. And never forget what Giuliani said, which is we have a lot of theories, we just don't have any evidence, which is really the motto for their whole legal operation.
I saw a number of conservatives yesterday either being mad or pretending to be mad. Sometimes it's hard to tell the difference about Ginny Thomas having to testify, and basically accusing the committee of only doing it because as a means of humiliating her and her husband, Clarence Thomas. And I'd like you to respond to that.
Well, first of all, she testified, as she repeatedly has emphasized, voluntarily. So it was her decision to come. It wasn't under a subpoena. So if they're condemning someone, they're condemning her for participating. But she did the right thing in the way that more than 1,000 American citizens have done in coming forward to talk about exactly what they know. It's a relative handful of people like Steve Bannon or Roger Stone who either just blew us off or come in and cite the Fifth Amendment privilege against self-incrimination, which is their every right to do so. But the vast majority of people are trying to advance the search for the truth. This was our democracy. This was our government that was under attack. Donald Trump tried to overthrow the election of the people. Abraham Lincoln said that an insurrection is an attack on the rights of the people, because it's the people that are involved in the process of choosing the president. And they decided just to short circuit that and overthrow it and install Donald Trump as the president.
What are the great near misses, I think, of January 6th as we learn from your committee and as we review footage and as many of these cases work their way through the federal courts in D.C., is the fact that many of these people were gun owners. A few of them had guns and weapons, as we've learned, but the vast majority did not. And largely that was because of the very, very restrictive gun laws in Washington, D.C. And I think it's fair to say that the lack of guns that day by the mob, by and large, saved many, many lives and saved us from something almost unfathomably much worse. You have an op-ed that you just wrote about the Second Amendment and guns and insurrection. What's the argument you're making there?
Yeah, and let me just underscore your first point there, Chris, which is absolutely right. There were thousands of firearms that were brought to Washington. Most of them were left in Virginia or in the trunks of people's cars because of the relatively strict laws the District of Columbia has against carrying weapons, firearms, semi-automatic weapons in public, and so on. But my op-ed in the New York Times is an effort to take issue with something that I've heard repeatedly from GOP colleagues and increasingly since January 6th, which is that the purpose of the Second Amendment, they say, is to allow the people to rebel against the government or to have an insurrection against the government if they perceive the government to be acting in a tyrannical way. The problem with this is that It's completely at odds with the text, the structure, the meaning of the Constitution. It's not rooted in anything in the Second Amendment, and it's just an urban myth. It's just a dogma that's out there, but the Constitution repeatedly opposes insurrection. Article 1, Section 8, Clause 15 says Congress has the power to call forth the militias from the states in order to suppress insurrections. The Republican Guarantee Clause says Congress must guarantee to the people of the states a Republican form of government and must put down domestic violence. It is treason, of course, to levy arms against the United States. And Section 3 of the 14th Amendment says that if you have sworn an oath to uphold and defend the Constitution and you breach it by engaging in insurrection or rebellion, you can never hold office again. And so they say, well, the Second Amendment actually gives you a right to engage in insurrection, but there's nothing in the text. The language of the Second Amendment is suggested. They have no history for it. And so it's just nonsense.
It is nonsense. I agree with you. Congressman Jamie Raskin, thank you so much for your time tonight.